Do you want me to just start? Okay. Good afternoon, I don't think it's working. Good afternoon, everyone. Just going to start our next panel. Welcome back from lunch. So in planning this panel, we wanted to leave you with practical advice on how to deal with judicial pretrials. On my left side, I have the Honourable Justice Shannon McPherson, who was appointed to the Ontario Court of Justice in Newmarket in 2017. She currently presides in Brampton, Ontario Court of Justice. After her call to the bar in 2002, Justice McPherson practiced law as Crown Counsel with the Department of Justice in Brampton. From 2007 until 2017, Justice McPherson was in private practice representing clients charged with criminal offenses as well as victims of crime. Justice Victor Giourgas was a criminal defense lawyer for almost 18 years. His practice was varied and included indigent defendants with mental health and addiction issues, professional regulations, jury trials, appeals, and quasi-criminal matters, including Competition Act and OHSA matters. He was appointed to the OCJ bench in 2017 and has presided in Newmarket, Old City Hall, and now at Armory Street in Toronto. Joe Wilkinson was known as Joe, graduated Osgoode Hall and was called to the bar in 1999. In 2020, he started Wilkinson Legal Professional Corporation. Throughout his 24 years of practice, he has conducted numerous appeals and trials across the province in complex criminal matters, including jury trials, project cases, frauds, drug prosecutions. Mr. Wilkinson has appeared at all levels of court in Ontario, including the Supreme Court of Canada, and is a frequent visitor to the Court of Appeal for Ontario. Please welcome our panel.
Yay, Joe.
Okay, thanks very much for the kind introduction and for everyone hustling back from the truncated lunch to dive into the judicial pretrial panel. I've got it up. Okay, amazing. Before we get into what might be described as the sort of nitty-gritty, I wanted to just ask the both of you if you could give us some idea of what a day doing JPTs in Toronto, Justice Giourgas, where you preside, and in Brampton, where you sit, Justice McPherson.
Sure. In Brampton, we do all of our judicial pretrials over Zoom. There's no opportunity at the end of our judicial pretrials to go on record and articulate some of the issues or protect the record in any way. So they're all off-camera discussions, and it's really important that you keep that in mind for when you come back to address the matters in the weeks that follow. We have currently 3 pretrial rooms. Each room will host about 10 judicial pretrials, save and except more complicated files or multi-accused files. They're 30 minutes each. Usually we get a synopsis in the criminal record, if any, for each accused person. It's supposed to be 3 days in advance, usually the day before. That's how I would describe what we're doing in Brampton right now.
Sir, did you say how many JPTs you would typically do in a day where you're doing them?
10 slots, yeah.
Okay.
And then often we'll add one in the morning, a continuing pretrial before, one at lunch, and sometimes after, but 10 scheduled JPTs. Is that not enough?
I think that's, we have a question already? No, it's technical issues.
Okay, thank you, sorry.
I thought we had a question.
Same question to me.
Yeah, well, I want
right.
both your perspectives.
It's
Assuming
pretty much
the jurisdictions are slightly different.
Yeah, not really, actually. It's pretty much exactly the same. I'm far less diligent, though, than Justice McPherson, and I don't schedule anything before, during lunch, or after. 10 a day is enough. they almost always all go, and that is how they shape up. So even minor frustrations because of that tend to be magnified, at least in the jurist's mind, I suspect. So that explains our distemper sometimes.
Are you also, I mean, maybe this is stuff that people know, but in Armory, are you also Zoom only?
Yep.
And are you on record after the JPT?
No, as I said, it's almost identical to the situation in Peel. It is Zoom only, different day than the matters next up, and we just discuss and then remind the lawyers that they need to put certain things on the record, and we hope that each side polices the other in terms of what needs to be said.
Okay, so this brings up, I think, a common important point, and that is with the liberal use of Zoom for JPTs, I think in most jurisdictions now, and them not always coinciding with an appearance on the record, it's very important that you somehow document the positions taken coming out of the judicial pretrials, especially in the Ontario Court of Justice, because as we'll come to soon, you ain't getting a form on the other side of it that maps out those positions. So particularly if it comes to something that's important in terms of a position the Crown takes that reflects on Jordan delay, you have to adopt a process whereby you somehow document that while it's fresh and that the passage of time doesn't deplete your memory, the Crown's memory, and leads to disagreements. In our office, what we tend to try to do is to send out an email to the Crown right after the JPT is done, which sets out the positions we've taken, any problematic positions the Crown has taken, and so that's fresh in your mind. And if there's no response back saying, Wilkinson, you're out to lunch, what are you talking about? We never said that. Then down the road, when you go to file the email on the 11B, it's going to be pretty hard for them to say, oh no, that's not right, that's not what happened. So I think that's a very important practice point to keep in mind. So the second slide just really has an outline of what the purpose of a judicial pretrial is. There's a couple cases there for you. It's discussed in the paper as well. They're all relatively familiar, I'm sure. One of the things I wanted to ask both of the justices is, apart from the obvious outline of the purposes of the JPT and what you're all told to achieve when you get the job as case managers, do you have any agendas of your own at JPTs as a common practice, or do you let them be largely driven by the lawyers?
I have an agenda, definitely.
Okay.
I have an agenda in the room. In Peel, we're dying. We have an 11B problem like no other place. And so whether you're here to talk about a time estimate or disclosure, I am every time going to still try and have that conversation about resolution. I certainly want to talk about the things that you want to talk about, and I'm happy to do that first, but I'll always want to talk about a resolution. And I also want to bind both sides if we are talking about time estimates. And I think far too often, at least when I was practicing, the Crown would make comments like, this is for the trial Crown, I'm not going to bind the trial Crown. We don't know if we're seeking to tender the accused statement for cross or otherwise. And so my goal is to make sure there's a decision maker in the room making decisions so that we can really estimate time properly if we can't resolve.
Okay, Victor, same question.
My goal, usually when conducting a judicial pretrial, is to see if I can resolve the matter. and I try to glean as much as I can from the materials that I get, which are usually pretty sparse. It's just the police synopsis and the criminal record of the defendant if they have one. And, even on the face of the synopsis, sometimes you can see problems with the case, or you can flesh that out a little more in terms of asking the parties to explain the facts a little more fulsomely. And from there, I see if we can reach common ground. I'll do that a lot more if I think counsel are inexperienced. I'm just being honest here. If there are senior counsel who I know on each side, I'll do it less because I assume that there have been some discussions in that regard. But if they're younger, or if I think one of the crowns or the particular crown is unreasonable, I'll push it more and try to see if we can get to a place where we can forego having to set trial dates.
Okay. The next slide is about the expectations on the parties for a judicial pretrial. And in the Ontario Court of Justice, there's actually a rule that sets out what people are supposed to be able to do and positions they're supposed to take on certain things set out there. So it's 4.2. It's in the rules. It's definitely important to keep these things in mind because folks like Justice McPherson and Justice Giourgas are going to expect us all to show up and be ready to go on those issues. There's also, in the next slide on the same topic, a helpful outline from a Superior Court decision, Regina and Brown, which reinforces many of the same things. It's common themes you'll find between the OCJ rules and the Superior Court decisions. My question to the panelists is, beyond these sort of obvious and well-known expectations, do you generally have additional expectations of the Crown and the defense, and are they different?
Sure. Well, for me, the most important thing is show up. I'm surprised how often counsel think that judicial pretrials are optional, or that the time slot is, approximate, and they can show up whenever they like, and if they show up at all. I've had to call out senior lawyers. I email them or call them directly and leave messages on their voicemail, inquiring as to the reason for their absence and our inability to reach them, because the party opposite will usually call them first and have no luck, and then I make them show up in court on the record to explain their absence if I'm not able to reach them. So that's one thing. The other thing is, I think you have to, as counsel, given whatever the nature of your case is and knowing your client, think about what is going to concern the judge on a judicial pretrial. And I know Brown addresses that to some extent, but you should come prepared to be able to discuss the case in some depth, the weaknesses, your client's wishes insofar as possible resolution goes or the outcome goes. I think those are all really important things. And if you've thought about these things and you think your client is on his way, get some materials, is on his way to a resolution or her way to a resolution, get some materials in advance, sort of setting out where the defendant is at that point in terms of any work they may be doing to address their issues. Nothing impresses crowns more than steps, concrete steps that your clients take. And I've seen this so many times as a judge, and when I was defense counsel too, but especially as a judge. Crowns are impressed by that sort of stuff. It pads the record, and it also allows them to go to their superiors if there's some question about what they can or cannot agree to, with concrete information in their hands in order to effect a resolution that hopefully will be favorable to your client. So that would be my advice.
So I just have one follow-up before we go to you, Justice McPherson. So on the just show up thing, how many points am I getting shaved off the global sentence for just coming? Like, is that the low water mark?
Well, you, none.
No,
But,
okay.
but others, depends on how much I like them.
All right, Justice McPherson, same question for you.
You have a question?
Oh, sorry.
Am I allowed to ask a question?
I think it's, yeah. Am I right about
I
that?
don't think I need to walk over to the mic.
I can hear you. Hi.
What's your perspective on skipping the CPT and just going straight to the JPT, specifically in Brampton and Hamilton, where they don't even bother assigning a crown until after the JPT? So all the CPT does is, hi, you got disclosure? Yep, okay, bye. I mean, like, could we just not just go straight to where it matters?
I'm going to say no. And the reason why I say that, I appreciate the issues that you have in Brampton in particular, but so many of the cases can be filtered out before they ever need a judicial pretrial. We've just added an additional JPT room in order to meet the needs of so many cases, but if we're setting them down for every matter where a Crown pretrial reasonably could have addressed the resolution, the issue, the time estimate, then that should be done. It's also helpful from the perspective of some of the issues can already be worked through. So I would really urge you to have that Crown pretrial first.
I agree. In Toronto, it's different. The crowns are assigned almost from the giddy, and as a consequence, your discussions with the Crown before the JPT are going to inform the direction that the JPT will go. And I think you need to have as fulsome discussions as possible with the other side before you show up for a JPT. You know, the groundwork should be laid as to where we're heading, right?
You know, I would also, I think we have another question, but let me just add one thing to the answer to this one. I also think you're passing up a bit of an opportunity, even where you have the position of indifference from the Crown, because like if you make best efforts to try to have that meeting and to sort the stuff out before you show up at the JPT, and all you get is nothing, like nothing, then you're setting up the Crown to be on the back foot, because what's the first thing you're going to say when you're asked, well, have you had the conversation with the Crown yet? And you'll be, oh, I tried 1,000,000 times. This is the whole reason why we're having this JPT, is because I couldn't get anyone to meaningfully discuss this case with me.
You would be surprised at how often we hear that.
Yeah.
So Joe makes a good point.
So I don't think you should leapfrog it without at least making some good efforts to try. Sorry, hi.
Hi. So the JPTs before COVID, I found really useful because they were in person. They were usually in the judge's chambers or library, and you could really twist arms if necessary or get down to reality. I find in this business of showing up, if you mean virtually showing up, where the judge is actually sitting in a courtroom and says, okay, we'll simply go off the record, with great respect, almost useless. Because it's and especially if you know the lawyers, you're able to get much more effective results.
Why? Because they might fear that you might reach across the table and hit them, or what is it that that that's it? Okay, all right.
You know, it just, I just don't find, and maybe it's a matter of sort of personal relation. I'm just wondering, wouldn't you rather have in person, or maybe I'm
We'd rather have in person for everything, but the realities, okay, as they've evolved, particularly since COVID, are such that that's never going to happen again. Zoom, I think, is a reasonable substitute. I presided at Old City Hall for a couple of years, and we did them by teleconference, not by teleconference, teleconference, by phone, which was terrible because you couldn't even see them. You couldn't look the lawyers in the eyes. But being able to do them by Zoom now, for me, is a luxury compared to what I used to have to do at the hall.
Well, again, except you were doing it face-to-face.
I was in Newmarket. I was doing them face-to-face in Newmarket. I can see that being a positive thing, but it ain't going to happen again. I mean, this is just the reality of it. At least that's my view.
In Brampton, we're so short of courtrooms, even after the new build of the second part of our building, that there's no court for which we can have a physical meeting anymore, and so it will stay on Zoom.
But that, as I said, we used to go into the judge's chambers or into the library. Anyway.
I think the other thing you'll find, we have another question here. Oh, 2 more questions. Holy. I think the other thing you'll find is that Zoom is letting people get quicker JPTs than they otherwise might, because what you're going to be finding if you do enough of these things is justices are zooming in from other jurisdictions with extra bandwidth into the jurisdiction that you happen to be in, where you couldn't get a justice from that jurisdiction for in the order of weeks, whereas now you can get them almost under 2 weeks, I find. So there is some upside to it, although the personal appearance thing is something definitely lost. Sorry.
I think we're conflating 2 problems. One is the under-resourcing of the system. And I remember when Madam Justice indicated that they were dying in Peel. I think I first heard that in 1992. Now, that's not COVID, and that's not Zoom. That is a systemic political decision to under-resource this system, and you're not going to solve it with technology. The other thing is that Zoom has hidden costs that no one wishes to consider, starting with, in first appearance court, a loss of respect for the court, and also a limiting of advocacy.
No, that's true, but we're talking about counsel JPTs at this point, and
Yeah.
I don't mean to cut you off. But we have to try to cover what we're going to cover. So
The first JPT,
forgive me if I'm
the first
being
JPT
curt with you, but
I did up in Peterborough started with a very eminent jurist, now retired, asking the Crown, "Are you really spending trial time on this piece of crap?" Now, I submit it's a lot easier for him to say that in his chambers than over a Zoom call, and we solved that matter expeditiously. But you're not going to solve one problem.
I've said similar things over a Zoom call. I don't think, in fact, I think a Zoom call gives you more license to say things that you otherwise wouldn't say face to face. I think the other gentleman had it right insofar as that goes. But anyway.
On that note, please do not have your clients in your office while you're having a JPT, or invite them to Zoom in. It's an off-record discussion between counsel.
Yeah.
Okay, we have another question.
Yeah, one quick question.
We have 5. I thought we have 8 minutes. What?
Yeah.
And questions at the end?
Well, can I ask one?
Okay.
I'm counsel.
Look,
and you're
I'm
not
just showing up here. You guys can do whatever you want, as far as I'm concerned. But
We're not actually in the courtroom, so I figure, what the hell, I'll just bend the rules.
Yeah,
Are
okay.
you seeing more duty counsel?
What's your name again?
It's right here. It's close to my heart. You can't see it.
I can't see it.
It's the wrong side. Are you seeing more duty counsel?
We don't see duty counsel in Brampton at all.
Nor do we.
You don't see
Except for self-represented
You don't
litigants
see any duty
occasionally.
counsel doing any JPTs, even assisting the self-reps?
No.
Occasionally with self-reps, but it is so rare as to be not worthy of
Okay, fair enough.
consideration.
See, that was quick.
Yeah.
Okay, thanks.
Wow.
Now, sorry, how much time do I actually have? There's this thing in front of me, a big screen, says 7:35. I have 3 minutes? What is this thing for?
Go ahead, Joe.
Yeah, talk to the guy who runs this joint. Okay, the next one is the forms, okay, and I'm going to try to go through this quick. So there's a new SCJ form, which is meant to, in multiple co-accused cases, it's meant to do this joint form that covers everybody's basis and all the different check boxes and everything else. My associates told me that they recently did one on a multiple co-accused case, and it turned into a 140-page document. Potentially unwieldy, but nonetheless, you got to fill out the forms if you want to get in the door and get anyone to listen to anything you have to say. That's the SCJ. And then I'm going to quickly go to the OCJ. There are no forms. There's one of the rules allows for the providing of materials in advance of the JPT, some of which have been touched upon. But this raises a bigger question for everybody, which we're going to try to expedite to. We're going to skip over the SCJ because there's, well, it's 140 pages, so, and we're running out of time. And let's talk about the OCJ because we have two OCJ justices here. You've already talked a little bit about what you generally receive to start it off the day before. What do you know about the accused person beyond their record and what heinous crime they're alleged to have committed?
Aside from what I can glean sometimes from the synopsis and the combination of a record, if there is one, not a lot. And so I often will open a judicial pretrial with, can you tell me something about your client? And I do that, one, because I want to know what you are able to tell me about their background, their vulnerabilities, what led them here, so I can start to think about moral culpability. But I also want the Crown to be listening so that they can have a look at where was it screened, what happened at the Crown pretrial, and where can we go from here. So whether or not you're there to start and estimate time, I want to know about your client. If you provide that a few days in advance, it's invaluable, in my view, for your clients to have that on the table before anybody even comes into the room.
Justice Giourgas?
Yeah, I agree. The most successful JPTs I find in terms of advancing resolution that seems unlikely at the outset are those where the defense provides materials. It is, I mean, it should go without saying that you should participate in the process to the greatest extent possible. Otherwise, you're giving the other side the advantage, right? So why not get as much stuff as you can before the judge? I know some of you have the attitude that, you know, JPTs are there in order to, you know, pardon the colloquialism, screw the defense, and to make sure that we follow a certain path and what have you. But you know, most of us don't, on the bench certainly don't think that way. And you know, we're going to do what we can to try to create as fair an outcome as possible here, and by fair I mean fair to the defendant. So I think that it's imperative that you participate in the process at every step, including at the judicial pretrial.
Okay. Can you each, very briefly, without naming names, give us an example of a case that helped you in your case management role where the defense provided something that you were impressed by or thought, you know, oh, this is really useful?
I see a lot of really great work, actually, from defense counsel in judicial pretrials where I receive Section 21 materials, where I receive counseling they've done up front, and also a memo about the triable issues, if you feel like that's something you can disclose in the JPT. I recognize that defense counsel can't and won't always be able to outline for the Crown, here are the holes in your case. But where you can, and where you can combine that with all of the great things your client's done and all of that background information, I really see the Crown's open to that kind of material, and I most certainly am.
For sure. I agree with Justice McPherson. I am going to name names. when I was in Newmarket, a couple of lawyers were jointly representing a defendant, Louis Genova and Rudy Covray, and I think Louis is here. I saw him earlier. There he is in the back. They provided me with volumes of materials about not only the strength of the Crown case, and they got into it, by presenting all this other evidence that weakened the Crown's case in summary form or in terms of statements, things from the disclosure, and all kinds of stuff. And the Crown that was initially assigned to the matter, I think, had to take a step back. Paul Tate was ultimately called in to conduct the continuing judicial pretrial. Paul was the Crown in Newmarket, and ultimately he withdrew very, very serious charges against Louis and Rudy's client. And that's as illustrative and instructive an example as I can think of. So that's what I can add.
All right, so I think we're out of time. Thank you, Victor. There is a sample JPT memo appended to the paper. If there's one thing you can take away from this, I think it's you should seriously consider in every case where you're able to try to put something forward from the defense to front-end load the jurist's information about your client and your position in both the Superior Court and in the Ontario Court, because otherwise you're passing up what I think is a golden opportunity for advocacy for your clients.
If you send it at 4:30 the day before the JPT, we don't get it in time to actually review it, though. So
I review everything the morning of, so it's good for me.
So
But Justice McPherson's advice, I suspect, applies to almost every member.
Get it in early for McPherson. Giourgas doesn't care.
thanks.
Thank you.
So we want to thank our presenters, and we appreciate the enthusiasm from the audience. But for the future panels, can we reserve questions to the end if there's time, just so that our presenters can get through all of their materials? But the enthusiasm is amazing. Usually people are asleep at these things. And our next panel will definitely keep you awake. Matthew Gourlay is about to do the intro, and I hope everyone sticks around for this one.